Hello, and welcome to the Law Awareness Weeks at CDC 2022. This webinar is part of Law Awareness Weeks at CDC 2022. It is a collaboration between Law Society Pro Bono Services, the 5 Community Development Councils, NUS Faculty of Law, SMU School of Law, SUSS School of Law, and the Singapore Corporate Counsel Association Pro Bono Chapter. It's also supported by the People's Association. My name is Sarita Misir, and I will be your host for this webinar. Today's webinar is on harassment at the workplace. Is help available? First, let's start with some housekeeping matters. Today, we'll be using Pigeonhole Live for our Q&A session. You can submit your questions at any point in time during the webinar and also upvote any questions that interest you. If you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at into your address bar. Next, key in our event password, which is LawCDC05, as shown on the slide on your screen. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole Live on your device. If you're viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole. Please note that today's webinar is not intended to substitute for any form of professional legal advice. If you require specific legal advice, please consult a lawyer. Okay, with that out of the way, I would like to introduce our panelists for today's webinar. I'm extremely excited. We have a fantastic panel. It's not always that you get, the real names in this field, right? So we have Patrick. I think Patrick is very well known to everyone. Patrick is the Assistant Secretary General of NTUC and also Director of NTUC's Legal Services and Strategy. Concurrently, he's also an elected MP and also a member of the NTUC Central Committee. Amarjeet is wonderful. Amarjeet, she's a partner at Withers Carter Wong. She's an advocate for gender equality. She has been consistently recognized as a leading lawyer in the area of labor and employment across global legal directories. She's also regularly quoted by the Business Times, Channel News Asia, BBC as a Singapore employment law expert. She's a forerunner in training and performing cultural assessments on the Me Too movement and tackling workplace sexual harassment in both her professional capacity and beyond. As the global head of diversity and inclusion at Withers, Amarjeet leads a working group within the firm that is represented across its global offices to proactively plan for diversity and inclusion initiatives and activities. Patrick, Amarjeet, thank you both for joining us today. It's fantastic. I'm so excited to start. So let's start first, for the benefit of our audience, with a short 101 course, a crash course really, on what is workplace harassment and some examples. Amarjeet, let's start with you. You're really the expert in this. You face a lot of these issues. Can you tell us what is workplace harassment? And also, I think it's also exciting to find out some of the examples of workplace harassment that you have faced in your practice.
Sure. Thanks for the lovely introduction, Sarita. Good evening, everyone. I'd like to start off by saying yesterday was World Mental Health Day. So I think this is a great juncture at which to be discussing workplace bullying and harassment, which almost invariably has an impact on the mental health of victims. So let's jump into the topic of what is workplace harassment. Now, generally, workplace harassment is viewed as a form of a more serious type of bullying that takes place in a workplace setting. It usually arises when one party demonstrates behavior that causes or is likely to cause harassment, alarm, or distress to another party. Now, why is this so damaging? It creates an environment where an individual's dignity is impacted and violated. It can create a hostile or toxic workplace and an unfavorable work environment where people don't feel psychologically safe. And I think that is at the heart of the risk that workplace harassment poses not only to victims, but also to employers that allow such behavior to go unchecked. Now, let's talk about where and how it can happen. It's not necessary that workplace harassment happens in the confines of your office. It can actually happen outside the office premises, for example, at a client's premises, at a vendor's premises, at a work-related occasion, at a dinner, at a hotel after a workplace dinner, for example. So I have an example where it took place after a workplace dinner in a hotel context.
Yep.
So we need to move away from the fact that it has to happen within the confines of your office. Now, there are many different forms of harassment. The first is the one we are familiar with, verbal. So that usually happens where someone shouts, uses abusive language, mocks or berates others, colleagues, etc. That's fairly obvious. Physical as well, fairly obvious. Punching, slapping, pushing, poking is one we read in the news. Someone kept poking someone in the forehead, So those are fairly obvious. The ones that are more insidious in nature tend to be the non-verbal and non-physical, so the psychological form. Now, we're familiar with the terminology gaslighting. We are getting more complaints about employees being gaslit in the workplace, where their version of reality is denied, being undermined in front of colleagues. Another one that really affects people is being mobbed. So where a group gangs up against an individual. So sort of the mean girl syndrome, where they leave them out, they go for lunches, then they don't invite their colleagues. They go for meetings, they don't invite them. I think that can have a very damaging impact. So that's another form. Stonewalling, so just ignoring them, ignoring invites for meetings, ignoring emails, and diverting work away. These are all examples. Now, it's a sliding scale, right? So it can be at the more benign end, or it can be very, very damaging across all the different types. Then we go into sexual harassment. Sexual harassment is something that we are hearing about more and more. It started with the Me Too movement, which I think spilled over into Asia, and people started to speak about their realities a bit more. Sexual harassment is when there's unwanted sexual behavior. So whether it's advances or otherwise, right? So there are examples of this, which, when explained to members of the public in Singapore by Aware, made them realize, hey, actually, we've also been victims. So they were not aware of what constitutes sexual harassment. I think that's important. So let me give you some examples, since we're doing a 101. Things like pictures, jokes, gestures of a sexual, sexist nature, alarming or offensive questions about colleagues' bodies, their personal lives, their sexual activities, crude and distressing remarks. And then you move into the physical aspects, right? Unwanted touch, whether it's stroking someone's back, forcefully kissing them, or worse, right? We have seen a recent case where it actually spilled over into rape. So again, this is a whole spectrum. Now, when we talk about different communication modes, how does this happen? Some of it happens in person. Some of it happens via text, so in written form, which means that even while people are working remotely, it doesn't mean that they are protected from harassment, because we've seen more instances of harassment through written format while people were working at home and forgot how to socialize with each other. And then another factor I want to talk about is, what are the relationship dynamics? Is it only between employee and employee? Is it only between male and female? Actually, we need to move beyond these stereotypes, because it happens across different relationships. So it can be between a vendor and an employee, a client and an employee. So long as it's within the workplace matrix, it can happen. It doesn't have to be between a male and a female. For example, if it's sexual harassment, it can be between people of the same gender. In terms of employee and employee, it also doesn't have to have the power dynamic of superior subordinate. It can be, peers. It can be different relationships, consultants, etc. Any people you interact with.
Yeah, thank you, Amarjit. I think it's it's great that you've done this 101. I think it's important that people know that the many different forms, right, and the many different ways, and how, unfortunately, how prevalent it seems to be. I think, as we were having the discussion early on to prepare for this webinar as well, Amarjit was talking about some of the really, it's unbelievable, some of the facts, right? And I'm sure, she will share with the audience as we move our discussion along. So Patrick, let's move to you then. Patrick, the last 2 years, right, there's been a change in the way work is done, right? So we have a lot of non-traditional work relationships now. We have things like a lot more contract work now, a lot more things like traineeships, internships, work trials, things like that. We also have a lot more non-traditional, non-office, non-traditional, non-white collar kind of folks out there working, right? So, we have our frontliners, your security guards, your healthcare workers, your platform gig workers as well. So can you tell me then, from your you're at the forefront, of
Yeah.
the labor movement. Can you tell me from your perspective, right, as being part of the labor movement, what have you seen in terms of harassment or workplace bullying for these type of people?
Uh, Thanks to Rita and of course Amarjit for sharing the different kind of developments in this space. I think the last 2.5 years, in fact, the last 5-6 years, there have been quite a bit of developments in this space. Of course, we came up with the Prevention of Harassment Act and a whole series of tripartite advisories, guidelines, even regulations to look after this space, because increasingly we are getting more awareness amongst victims, at the same time also awareness amongst HR, human capital practitioners, as well as employers who are concerned about the space. And particularly so in the last 2.5 years because of the COVID-19 pandemic, work arrangements have changed, workplaces have changed. At the same time also the profile and the type of work arrangements and work relationships or employment relationships have also changed. Today, as we are speaking, we have something like 200,000 what MOM terms or Ministry of Manpower terms have as own account workers. Of course, in legal terms, we call them either independent contractors or contract for service. And we've been seeing quite a bit of that in the last 2.5 years, particularly with the pandemic. We have seen many workers who were previously in full-time, traditional full-time, part-time, or even contract arrangements going into two other new arrangements. Firstly, the contract for service, very much like your delivery riders, private hire vehicle drivers, and many other arrangements which are on contract for service arrangements. For example, like what we've seen during the COVID-19 pandemic, you have the safe distance ambassadors, various ambassadors across different frontline facilities, and also even people who do swabbing activities and administering vaccinations and looking after all the vaccination counters across Singapore. And all these, majority of them were in contract for service arrangements. So yes, such arrangements also call for different kind of formats because they're not in a traditional employment relationship, and therefore a different set of rules or regulations govern this space if and when they are being harassed, whether by fellow employees, colleagues, by bosses, and mostly increasingly we are seeing by members of public or people whom they serve at the front line. So though that's one big group that we're starting to see, we're starting to get a bit more concerned, and therefore there's this advisory committee that's looking at in particular this segment of workers, the so-called gig workers. I mean, there's various nomenclature. Some call it informal workers, gig workers, contingent workers, our freelancers. And of course, legally, we call it either independent contractors or contract for service arrangements. And that's one very, very important piece. We can talk a bit further later when we go into scenarios, but I thought that's one important new arrangement which requires a different set of rules, not your traditional workplace employment kind of labor legislation to cover this space, but POHA and a few other pieces of legislation have been promulgated to address this, and there's been few iterations and few amendments in the past couple of years to keep pace with some of these challenges. And you rightly pointed out, Sarita, that because of what happened in the last 2.5 years, not that this did not happen prior to that, but increasingly because of the frontliners, be it healthcare, private security, we have seen some of these cases on the social media, and it has spread out in the mainstream media as well. On some of these frontline workers, being victims of harassment, whether it's physical abuse or is it verbal abuse, and the whole list of different kinds of harassment, which Amarjit shared earlier. So we are seeing quite a bit of that, and we are particularly concerned, and which is why later we'll talk a bit more about some of the updates in the various pieces of legislation to keep pace, to better protect and send some deterrent effect to would-be perpetrators against such frontliners.
Yeah, thank you, Patrick, for that. I think it's great that you mentioned the POHA, you mentioned the ways that we can kind of protect, right? So now let's move on from the what is harassment into the how to protect and how to deal with it, right? So into recourse, basically. So Amarjit, let's start with you. I think with your experience, can you give us just some practical tips or pointers, right, for employees and also outside workers, right, non-traditional kind of workers, to how they can protect themselves? Right? What do they need to do in terms of maybe, let's just say they have faced like harassment, in whichever form of workplace that they are in. What can they do, or what should they do so that they have evidence, they can protect themselves, and they can take this forward?
Sure, Sarita. Before we jump into the legal recourse, I think it's very helpful, as you say, to talk about the practical aspects of how do you even start to put together a case before you seek recourse, right? So what are the practical avenues? And I think this should cut across traditional employment as well as what Patrick shared as being within the gig economy or the informal economy. Now, firstly, workplace bullying is prevalent. A study showed that in 2019, 1 in 4 workers in Singapore reported having encountered bullying in the year before, not in the many years before, but in the single year before. So that speaks to me and tells me that actually it happens quite regularly. So, these tips should help any worker who might be facing what they consider to be bullying. If they are not sure, at least it helps them frame their thoughts as to whether they are being bullied or harassed. So the first thing I would say is familiarize yourself with company policies, right? Most companies, especially the MNCs, will have codes of conduct, which should clearly state conduct that the company will and will not accept. So within that, right, there will be policies which should cover things like bullying, harassment at the workplace, discrimination at the workplace. Familiarize yourself with this so that you understand the house rules of your organization. That's the first thing. The second thing to do is check if there's a grievance policy. Does the company have established lines for confidential reporting, such as employee assistance lines or whistleblower lines? Does the company have a particular process you need to follow in order to raise a grievance? Knowledge is power, right? So arm yourself with all this information. If there's an investigation, what are the procedures that the company follows? All of this is important as you decide what to do. That's the first step. The second step is make the facts clear, right? Write a clear statement of the facts, what has happened. And the facts should, to the extent possible, be supported by evidence. Now, many of you may say, yes, but what the person says is never in writing. So how do I get evidence? Very good point. Happens more often than not. One good way to create a paper trail is to send yourself an email on the same day itself saying, this is what happened, this was what was said, these are the people who witnessed this or might have been around. And you create a contemporaneous record of what transpired. Now, if you think things are going wrong, you still have the option of doing an audio recording of a conversation. So there was a famous case of a lawyer who ended up physically and verbally abusing staff in the office. And I think one of the staff got alarmed and did an audio recording, which then was produced in court. So I think that goes to gathering evidence, taking screenshots of messages, for example, if there's anything in writing, keeping records of emails. All of this helps because it reduces the ambiguity in a he said, she said scenario. It helps you buttress your claim. And then if you are in a position where you need help, right, you should understand the role of active bystanders and allyship, because you may have friends, you may have colleagues, peers, mentors within the organization who can provide you with support, who can advise you on how you may want to raise this within the organization. Now, this is not a battle, right? Because the company is also there to protect you. It's about engaging with them meaningfully. So finding the right allies within the company can really be helpful. And that goes to seeking internal support, right? Who can help you? Identify people who can assist. Now, it never, in my opinion, it's never a lost opportunity to speak to the person who you believe is harassing you as well. Give them a chance by making it known that you don't appreciate certain behavior rather than just escalating it. You know, as humans, sometimes we may not even be aware that we may be offending someone because we have different ways of looking at things. We may have certain biases that we are not aware of. So having a conversation with them first is a practical tip. Now, you may say, yes, it may work in benign cases, but if I'm dealing with a narcissist, they will just deny it. Well, at least you give the narcissist a chance, right? And they will know that you give them a chance. So maybe just approaching the person and having a conversation is helpful. And the main thing which I highlight here is look after your mental health, your psychological well-being, because these things do affect our mental well-being. So if you need help during this process, seek help where needed. There are many organizations that can help. You may want to just look into this so that you are supported through your journey.
Yeah, that's great, Margie. Thanks for all these practical tips. I think I want to just go to a couple of the questions that deal with evidence. I think that's a very one of the most critical points in terms of how to deal with and how to protect yourself against sexual harassment. So we have a couple of questions about how to establish evidence of, you talked previously about psychological harassment, which is insidious because it's gaslighting. It's all these things where you start to doubt yourself. There might not be screenshots, there might not be recordings available, right? So, how would you gather evidence in a case like that?
Okay, that's a great question. Those are the hardest types of cases to prove because the smarter bullies don't leave a paper trail. They are very smart about it. So what you can do is engage third parties who were there when these things happen, right? To get a confirmation from them that these things transpired. Again, do a contemporaneous record, right? So, sit down in the evening at the end of the day, say this happened around this time, this is what was said to me. These were the people who were there. So you are creating a contemporaneous record, a snapshot of that point in time on that day of what happened, right? You are not doing it 2 months, 3 months later where people can say it's self-serving or you might have forgotten. Do it on the day itself. So you are generating the necessary records and also engage people who might have been there as witnesses. Now, they may not be willing to say anything and you have to be aware that there's a sensitivity because they also have jobs to protect. So you can't rely wholly on third parties because they may not be ready to stand up for you. So try to create your own evidence where possible.
Yeah, so Amarjit, I also think, your same tips that you have for psychological harassment, I would assume is the same kind of evidence gathering that you have for verbal, for physical, it's the same. Physical, there's probably a bit more, maybe, a bit more physical, tangible kind of thing, marks that you can see. But I would assume it's the same across the board as well, right? So one way is that, one very important point that you mentioned is that if you don't have things like video recordings, screenshots, nothing like that, no emails to show, you should always just take, as detailed a note as you can at that point in time, right? Whenever you're available, and then email yourself so that there's a timestamp there and it's recorded as at that point in time, right? So, okay, yeah. So
that's shared with an ally on the same day. Someone who will say, yes, she shared it with me at that point in time, right? That also helps as a counterpoint to what you are saying and to support and buttress what you're saying.
I can't, I really can't emphasize more what Amarjit mentioned because whether you're gonna go with criminal sanctions against the perpetrator, whether you want to take civil action, or even raising issues with the union or even with the Ministry of Manpower if it goes into a dispute. Bottom line, you still need evidence, and evidence in all sorts. Increasingly today we have more smart devices, so it makes it a bit easier compared to many years ago where we cannot really get a very clear picture, a very clear or clarity of audio. And these days, there's also CCTV recordings of what happened in some of the cases that went to court, where there are CCTV recordings at the workplaces. I think particularly relevant, if you recall in some of the cases, for example, like in the bus depot, where bus drivers, now even bus drive within the buses, within taxi cabs and stuff like that. In many parts of the world, not just in Singapore, we have all these CCTV recordings to ensure that we have sufficient evidence in case to better protect both sides.
I totally agree. CCTV recordings are brilliant. I had a case recently where the event, it was a workplace event outside the office, was at a dinner, and the group went to certain restaurants and bars, and we needed the evidence to set up the case as to what happened subsequently, which took place in a hotel, unfortunately, but we couldn't obtain the CCTV evidence. So even within that, right, you need to keep your own evidence because sometimes you may not be given access, particularly if it's a third-party location and not the office premises. So even then, keep a record. But I think Patrick's point on CCTV is brilliant because particularly where there's physical violence, it really shows. Verbal is harder unless there's audio recording, which most places don't keep.
That's right.
But for physical, it's actually very, very helpful.
Yeah, that's great, Amarjit. So maybe then, we've talked about the practical tips. Why don't we move on to, some of the, can you just, Amarjit, maybe, let's go with you first. Can you just briefly talk about some of the civil and criminal kind of remedies? Let's just say, harassment is serious enough that you have tried internally, you've tried some self-help methods, it just doesn't work, right? You want to go and take it forward. What can you do in that case?
Okay, so let's start with the POHA. As Patrick correctly said, I think the POHA is the introduction of the POHA court and the Protection from Harassment Act has been a real game changer. The POHA court has been designed to make it simple, expedient, and cost-effective for lay people to make complaints. so that they don't have to face all the barriers of having to engage a lawyer, etc. They can just file it online. So if you think you are a victim of harassment, you can actually go online and file a POHA case. Now that cuts across the different types of harassment. So the POHA Act covers different types of harassment. Harassment, intentional, unintentional. It covers cyberbullying. It covers stalking. It covers doxing. It covers a whole host of forms of harassment. So it's actually very comprehensive in that it gives a wide scope of issues that are protected. So within the POHA framework, victims can seek civil and criminal remedies. Civil means that they can actually sue for monetary compensation. The POHA has a cap of 20,000. So it is capped, but that's part of the system to make it expedient and quick for lay people to get justice without having to go to the High Court to sue, for example. Criminal remedies are also part of the POHA framework. So certain actions, as you say, harassment can actually constitute civil actions, civil offenses. So within the POHA framework, they can also seek remedies within that. Now, certain types of other harassment are penal code offenses, okay? So they also have recourse to going to the police, filing a police report, and this is where your evidence becomes very important, right? So if you're going to the police and you're going to file a police report, bring along your evidence, give a statement. If you have someone who witnessed the actions, bring them along so they can also give witness statements. You can identify them to the police who will take statements later. And I think knowing which types of cases could form criminal offenses is also important. So for example, verbal abuse. If it crosses into the threshold of criminal intimidation, this is a criminal offense. Physical abuse covers there's a whole spectrum, right? Voluntarily causing hurt, assault, etc. That can also be a criminal offense. So making a police report is an avenue that is open to victims. Use of criminal force, for example. Sexual harassment, you've got outrage of modesty as an example. You've got rape at the more serious end of the spectrum. So these are the sorts of broad remedies that are available. And I think if unsure, there are a lot of resources that can point them in the right direction.
That's
And
right.
that leads me to Patrick.
Yeah, in fact, you hear very, very big words like POHA and penal code, especially for many of you who are laypersons, but not to worry. In fact, for POHA, there are two go-to places that you can get a bit more information and be guided simply. Of course, the State Court's website, including the Law Society Pro Bono Services website, have resources. In fact, very, very useful resources. I use it myself as well, and to get a quick reference guide, especially in terms of how you file, when to file. The entire process flow is in layman terms explained for all of you to go through and to guide you along. So that's one. The other resource actually, as part of our LawWorks partnership between the Law Society Pro Bono Services Office and the Neighbour Movement, NTUC, we actually came up with a pocket series, the pocket guide, particularly on the go-to a simple pocket guide, which is accessible online. We have put the PDF copy online, both in the NTUC as well as PBSO's web pages, which you can download for free. And we're coming up with the second iteration or edition. Look out for that. Probably later part of this year or next year, we'll be updating some of this, because there has been a couple of iterations and amendments to the Prevention of Harassment Act. And therefore, we're updating that piece of pocket guide and series. So look out for that. So these two are quick reference guides for you to go to in case you have any doubts, or if it's you want to navigate your way through the POHA court, which may sound a bit too insurmountable for you.
Yeah, thank you, Patrick. So actually, this is a great segue into the next point that I wanted you to speak about also. It's obvious from this discussion that the government, the tripartite partners, MOM, NTUC, Law Society, everybody, right, all stakeholders involved, look at prevention of workplace harassment very, very seriously, right? So can you speak then from the labor movement angle, right?
Yeah.
What kind of help is available for, victims or affected employees?
Yeah. I mean, I will share broadly, but essentially, you must firstly dichotomize between someone who is in an employment relationship and someone, as I mentioned earlier, the independent contractor or gig or a contract for service arrangement. So that's one dichotomy. The other dichotomy is also between someone who is an NTUC union member and a non-member. So I'll touch a bit on that. But before that, actually nationally, besides the POHA and penal code, which Amarjit has shared about, there are actually few pieces of useful resources and guidelines that have come up in the last immediately after the POHA was introduced. I recall speaking on it in Parliament, and I know we actually had this piece of legislation specifically to address harassment both in and outside the workplace as well. So actually, the POHA is quite a wide piece of legislation which has expansive powers in various forms and areas. And the ambit is sufficient to cover, like what Amarjit shared, both the online and the offline space. But more importantly, there are other few important pieces that came up. Firstly, is a tripartite advisory on managing workplace harassment. It's actually a document. Obviously, it's tripartite, meaning the government, the employers, as well as NTUC have come up with this simple go-to guide, useful for some of you who are tuning in, who are human resource or human capital practitioners, or even running human resource functions. And if you don't have the so-called HR policy, circular, or guidelines, you can use that as a good reference, and you can literally cut and paste. A copy we made available. We're trying to post it there for you to download it in the chat and messages, so you can download a copy of it. It was quite contemporaneously after the POHA Act was introduced. We had this piece, so useful for all employers who want to have some form of workplace harassment management measures and guidelines and policies. So that's a good reference point. That's number one. Number two, also Tripartite Alliance for Fair and Progressive Employment Practices, TAFEP for short. A tripartite entity looking at and they're actually specific tripartite standards and guidelines on this, and in particular on fair employment practices. Yeah, but later we'll talk a bit more about that and some of the developments, but that's the second go-to area. The TAFEP as well as the various TAFEP guidelines that come with fairer employment practices. And of course, the various resources which I mentioned. So if you are in an employment relationship, generally in the workplace, there's an implied duty of the employer to ensure that the workplace is safe and healthy for you to work in. So that's an implied duty on most employers, and therefore the workplace safety and health laws of Singapore, to a certain extent, would govern, ensuring that the employers provide a safe, and secure environment in the workplace. So that's one go-to piece, which sometimes we avail ourselves whenever there are issues on the workplace harassments. So that's one piece. The other piece, which Amarjit shared earlier, is the POHA and the penal code, which also avails not just employees in the employment relationship, but also the freelancers and the gig workers, because you can actually make use of these two pieces of legislation as well as other pieces of legislation, depending on the kind of acts or the kind of overt or non-overt act of verbal abuse, be Miscellaneous Offences Act or other relevant regulations, which you can tap on as sanctions against the perpetrator. Especially, for example, if you are a delivery rider and someone hurls abusers at you, or you are a private hire vehicle and then your customer or your client who is in your vehicle, does something to you, either gesticulates or do some threatening behavior, or even uses force on you. So those are pieces of legislation and regulations you can tap on, even if you are a freelancer and in a contract for service or an independent contractor without an employment relationship. And finally, the dichotomy between the union member and non-union member. For union members, if you are a union member, NTUC union member, and in whatever workplace, I've assisted quite a few unions as well as union members in this space. So beyond what we've shared earlier on the various pieces of legislation and tripartite guidelines, there are also the Industrial Relations Act, which allows unions to represent victims or affected members and workers to provide workplace grievance handling procedures to handle. It could be a skirmish between or a harassment between a supervisor or fellow colleague, etc. So union members can actually have access to this. We have union leaders on the ground, industrial relations practitioners from the NTUC and labour movement to assist you if you have such a grievance in your workplace, because there are various, I won't go into the details because that will take another whole session on industrial relations and in the workplace, but essentially there are measures under the Industrial Relations Act which we can embark or take action for on behalf of our affected members in a workplace.
That's great, Patrick. I think, I just want to emphasize again what Patrick mentioned previously, that, look at the TAFAP Workplace Harassment Resource and Recourse Center. I think it's got resources for both employers and training programs, etc., for your HR people, your supervisors, as well as resources for employees, right? So what to do, some guidance in terms of what to do, how to protect yourself if you have suffered from any of this kind of workplace harassment incidents. Okay, so I want to just briefly then move on into some of the, I think some of the developments and trends in this area. Amarjit, let's start with you. I think in the past 2 years, right, we've had a lot of people working from home. And, there were a lot of reports also that said that toxic workplace behaviors also moved similarly online, right? So now that folks are coming back to the office increasingly, at least a few times a week, what trends have you seen in terms of workplace harassment? Has it moved back to the office? What's going on?
So this is a very interesting question. I think a lot of this stems from changes to the way we work in the last 2.5 years, a lot of which were brought on by COVID. Now we've seen people come back to the office. Some of them seem to have forgotten how to conduct themselves in the workplace because they've been sitting at home. They've, not interacted with people in person. And I think they are refamiliarizing themselves with social norms that go hand in hand with being in a workplace or being in a physical space with someone. So this is the first panel I've done in person in 2.5 years, maybe. So, again, refamiliarizing ourselves. I think that change in work environment has caused some destabilization, some need for people to reestablish rules about how to work. So in the last 2.5 years, we've seen examples of people misbehaving over Zoom, behaving in a manner that's inappropriate over Zoom. And now we are seeing people misbehaving as they come back to the office. So I think it'll take some time to normalize and reestablish a social contract. Now, another interesting trend. Now, you might have heard about quiet quitting, right? I'm sure everyone's heard about it. It was splashed all over the papers, international, local papers. The converse to that is quiet firing. So what is quiet firing? Quiet firing is when, a person is treated in a manner such that they feel compelled to leave, or they feel like they're being squeezed out. And again, this is insidious, right? So it's not overt, mostly it's covert. It's managers behaving in a manner that wears down or chips away at a person's morale, etc. And they are being quietly forced. So the intention is that the company shouldn't have to fire them, but that they leave on their own accord. And I'll give you a very interesting example. Someone shared with me that someone in a tech company, if they want to fire someone, how do they do it? They will convene a meeting in a glass meeting room. They will invite everyone but the person who is being quietly fired, and they will do this 3 times. And usually on the 3rd time, the person, just after the 3rd meeting, the person will tender. Because we all have self-respect. And if you're being excluded to the extent that you're the only person not called to the table, you will get the message that you are not wanted. Now, from a legal perspective, this is quite a fascinating phenomenon, because in Singapore, we have a form of wrongful dismissal known as constructive dismissal, right? And that is where a person resigns. They're not actually dismissed, but they resign due to a cause of conduct or a cause of omissions by the employer, right? So fascinating. When does this become legally actionable? We are seeing more of this quiet firing because companies have to report retrenchments, for example, to MOM. Every retrenchment needs to be reported. So I think to the extent possible, this is an option of eliminating part of the workforce in a quiet and in a quiet way that doesn't hold them accountable. We've also seen managers who don't want to jump through the hoops and seek approval to let someone go, particularly where the person is high performing or there are no actual reasons for letting them go except maybe a personality clash. So this is a fascinating area. I think this warrants more exploration. And the third is what is called a disguised retaliation against victims or whistleblowers. Now, this is a fascinating area, right? So when we talk about people who face harassment, a part of the battle that they have within themselves is whether to whistleblow or not. Now, we are Asian. A lot of people decide that they're not going to whistleblow because they don't want to be seen as troublemakers. They don't want to change the status quo, and they believe in the hierarchy, right? So it goes against the grain for them to want to whistleblow. Now, the practical side of not whistleblowing is that whistleblowers often face retaliation. And this is not imagined, right? This is real. We've seen examples of the Wirecard whistleblower as a client. He had one of the most extreme forms of retaliation I have encountered in my career. He even faced death threats to himself and his mother. Now, of course, that's an extreme case. Please don't think that if you complain about bullying or harassment, you will face death threats. That was a very much more serious case of issues of financial fraud, etc. But it is true that whistleblowers often face retaliation. Now, this even happens where companies have policies in place that state that there should be no retaliation. So this is a real issue. This is something we work hard to protect whistleblowers from in the process of before they whistleblow through to after they've whistleblown. So that's part of why they seek our advice.
Yeah, thank you, Amarjit, for sharing that. I think let's move on, Patrick, to you then. Can you tell us, let me just use an example then, in March this year, the government issued the Singapore White Paper on women's development. And in it, there were a few action items, right, in terms of dealing with workplace harassment. Obviously, the white paper is meant for women in the Singapore workforce, but I think some of those action items are basically across the board, right? It doesn't matter how you identify. Can you speak a little bit about some of the developments in the labor movement, that whether they arise from the Singapore White Paper or not?
Yeah. Very earlier on, I alluded to the tripartite guidelines on fair employment practices. I think one good news or one major development is that we have formed a tripartite committee on workplace fairness, which I'm a part of. And if I may provide a very contemporaneous update, we're really still discussing on the scope, how we're gonna provide better recourse of, if workers face discriminatory practices or unfair practices in the workplace, whether they're in employment, exiting employment, or pre-employment. So I think we are deep in discussions. The details are not out yet. We are not finalized yet. We are really on the discussion table, consulting with many, and widely. And one key thing of this entire tripartite committee on workplace fairness is to discuss and come up with hopefully a piece of legislation which would kind of like embody the tripartite guidelines on fair employment practices and enshrine it sort of like in law. So I think that's one key thing we're doing. Many of you who are familiar with the tripartite guidelines on fair employment practices, in that particular deck of guidelines, we look at things like addressing nationality discrimination, addressing age, gender, and the whole other list. I think the top two were actually nationality and age, and gender came a close third. And this is publicly available information. We have discussed it in Parliament and Ministry of Manpower. Minister himself has shared where are the predominant cases of discriminatory behavior and complaints that have been surfaced to TAFED and MOM. So these are the few areas which we hope through this eventual piece of legislation called the workplace fairness piece of legislation hope to address. We'll probably hear more details of it probably next year. But like I said, we are really in the thick of the action and really discussing, consulting widely, and hopefully enshrine the guidelines into law and to better protect and look after against workplace discrimination. But more than that, workplace discrimination, in a way, it borders into harassment and it's a thin line. So I think more importantly is to cover the various spaces of the employment space and sphere. Secondly, is also one major development, as I alluded to earlier, is the advisory committee for gig workers, platform workers and gig workers. I think that's one area which we feel very strongly. As I shared, we have more and more of these workers, and they comprise almost about 9 to 10% of our entire Singapore workforce, and growing still. So I think we've seen the likes of many of these gig workers having to battle the front lines, battle with difficult customers, battle or interfacing with different segments of the community. So this particular tripartite committee, again, still in the thick of action and hopefully getting more details by later this year or even next year. But essentially, I think there are a few areas which we are very, very concerned about. Firstly, whether gig workers, because they're not in an employment relationship, not protected by employment laws, how can we better look after if they face work injuries, for example, if they are being knocked down or they are being pushed over and suffer injuries or even some health hazards they're exposed to. So what can we do to better protect them in that space? So that borders into this space on harassment and in sometimes even assault and battery by customers or members of public. So that's one area which that advisory committee is looking at. And of course, recently, unfortunately, I think this year we have seen many fatalities at the workplace. I think we have sort of like a record high for something not so good. And therefore, a new code of practice on chief executives and boards have been rolled out with a particular emphasis on workplace safety and health. And as I alluded to earlier, Workplace Safety and Health Act sort of encompasses or overarches the workplace when it comes to providing a safe and secure and healthy workplace, including something that's non-toxic and non-harassing. So that's another new development, although that was specifically look at addressing workplace fatalities, but increasingly we are seeing near misses and other of these related, including like we opened up by saying yesterday was World Mental Health Day. I think that's increasingly mental stress, distress, and other forms of manifestation of such illness are getting more common and plenty, particularly with what's happened in the last 2.5 years with working from home, hybrid work arrangements, work from anywhere and anytime. I think that has added and exacerbated many of these cases.
Yeah, thank you, Patrick, for that. I think it's very important that we see that there is movement, right, in terms of how to protect employees, in traditional employment relationships, as well as your gig and platform and your non-traditional kind of employees or workers as well. So let's move on then to our first scenario. Our first scenario basically is an office worker, who's facing sexual harassment in the workplace. I just want to emphasize as well to our audience members that like what Amarjit spoke about, I think in the very first slide that she spoke about as well, is that we tend to think of sexual harassment as a junior female who's being harassed by a senior male co-worker, right? But I think it's important to recognize that this is across the board, right? Sexual harassment is not just male to female, right? It can be vice versa. It can also be amongst peers, or it can be a junior harassing a senior, right? And it doesn't actually even have to be employees, right? You don't have to be peers or co-workers. You can be vendors, you can be a supplier, you can be a third party who's visiting the office and then harassing one of your employees, right? So Amarjit, I know, you spoke about a little bit of your experience in these areas, and you've done a lot of this kind of cases of sexual harassment. Can you tell us, can you just put everything together in terms of what you have discussed, right? And tell us, this office worker who's facing sexual harassment, what can they do to protect themselves? What should they keep an eye out for? How can they gather evidence? And basically, who do they approach, right, to get some help?
Okay, so let me share this across certain scenarios that we've encountered in terms of real life cases. I'll start with one particular case that has really left an impact on me. I think it's the first major sexual harassment matter that we handled. It happened in an MNC between two people in the C-suite level. So the male harasser was in the C-suite, so was the female victim. And you normally don't think this happens at that level. Again, as you say, the power dynamic is usually superior and subordinate. In this case, the gender stereotype prevailed because it was the male, but I have seen cases where it's actually a female superior harassing a male subordinate. So again, there are no rules about this, right? It's just about human behavior and how people choose to misbehave themselves. So in this particular example, there were some inappropriate text messages that were sent, which I think was helpful to establish the nature of the relationship, that there was already a sexual element being introduced, and it provided some basic evidence to buttress the position that the male colleague was not acting appropriately towards his female colleague. There was then an unwanted form of physical contact where he forcibly kissed her on one occasion. And there was evidence on that day as well, because he scribbled something on a napkin. So she happened to keep that because she had the presence of mind to actually say, hey, let me just go and keep that. Because it's contemporaneous, right? It happened at the dinner where where he then kissed her. So what did she do? She thought, let me speak to my HR, which is the obvious first line of contact. So she spoke to HR. She did this over drinks because HR was a friend. And when she shared with HR, I think she was appalled because HR laughed in her face and said, surely you must fancy him. He's very cute. And I think that to her was very deeply offensive because she felt very violated by the incident, but I think she felt even more disappointed by the reaction. I think this is the first warning to companies. Make sure your frontline HR practitioners, managers, etc., are appropriately trained to handle these kinds of complaints with the appropriate degree of sensitivity. Have an inquiring mind, but without victim shaming or blaming, which is what this HR did, right? So that put my client off for a good amount of time because she thought if HR is going to respond like this, the company is going to take the same line, right? They're going to blame me or say that I liked him or it was a mutual attraction, which is what every sexual harassment victim fears anyway. You fear that kind of victim shaming and judgment. And the guilt and shame really holds you back from complaining. But what happened is because she didn't reciprocate, she found herself being put on ice. So key projects were taken away from her. She was deprived the opportunity to be on new and exciting projects. She was increasingly being marginalized. And she realized that that was retaliation because she wasn't playing ball. So she filed a formal report. And she took mental health leave after doing that because it was very hard for her to file a report. Her employment was terminated while she was on mental health leave. Okay, so this is a 101 on what companies should not be doing, right? You shouldn't be, you shouldn't be doing any of this, right? So what happened is then they engaged us. We wrote a couple of serious letters. And this is a trend that's happening. We went to mediation to mediate the dispute. Now, why mediation, you may ask? Mediation is increasingly viewed as a good forum to resolve these kinds of sensitive disputes because it protects the confidentiality and the privacy of both parties. The victims in these scenarios also don't want to sing from the rooftops that they're victims, right? It's very hard for them to talk about these things. I think as Asians, we have even more of a mindset of shame and guilt because these things are not spoken about generally. And then to say you're a victim of something like this makes them hesitate even more. So mediation gives them a confidential setting within which to resolve these matters. So we actually managed to resolve this at the mediation with a healthy financial payout for the client. But what I want to highlight here for companies, employers, is that don't think that if you throw money at the individual or the victim, that all their problems go away. Because as we spoke about earlier, mental health is really at the core of how it diminishes their identity, right? Being sexually harassed affects them to the extent that we've seen clients with severe PTSD. They have anxiety, they have difficulty sleeping. And at the end of the day, after the mediation, they still have to go back to a family that quite often is broken because it affects their relationship, their interpersonal dynamics with their family members. So, sexual harassment is a complex issue. I would say that companies need to be mindful. As individuals, what should they do? Again, collect your evidence, seek allyship. Unfortunately, in this case, she didn't have an ally who was helpful to her, rather put her off. And if you should, nobody can tell you that you should report, but if you feel that reporting is the right thing to do, then you should do it because the aim is to change the company culture, right? To educate the company as well as to things that are happening within their four walls, which they can control, which they should control and change. I'll give you another example of sexual harassment. A male CEO, also MNC, visiting Asia on a regional trip, went to certain countries and had a workplace dinner. They were staying in the same hotel. It wasn't in Singapore actually. And on the back of the dinner, when they were going up in the lift, he forcibly kissed her a few times. Now, there was no evidence. It was he said, she said. It was in a foreign country. No CCTV coverage. And, she was in a much worse off position, evidentially. And again, the power dynamic was a lot more significant because it was CEO and fairly junior employee. And again, her role was being eliminated slowly. She was, not getting the choice project. So this is a trend, right? This is a trend. And usually they blame it on performance where this person has never been a bad performer. So again, this is a disguised form of retaliation. But before they could terminate her, we were engaged, and we therefore managed to get her good exit terms, such that she's now able to sort of rebuild her life and recover from this before she has to find employment again. So sexual harassment is something that has very long lasting, long ranging impact on the victims. And I can't stress that enough.
Yeah, I think Amarjit is, it's I'm hearing you speak, and I know we spoke about this before, but every time you tell me these things, I just feel so horrified, right? These are basically, I mean, as a, I'm not in the employment space myself, right? That's not my practice, but you would tend to think at least that, these are MNCs, right? MNCs have policies, right? MNCs have training, right? MNCs have all this, HR people, armies of them, right? To deal with this kind of thing. And we think at least one of them would be appropriately trained. But, the fact that both your cases, both your horrifying cases that you talk about, these are MNCs, right? I think I think it's really, an education in itself, right? Where it's not just your SME, your mom and pop, your Singapore small time companies, right, that are might face this kind of issues, right? I think it's important to remember that, MNCs as well, right, seem to be fully capable, right? Even your up to your very senior C-suite people are doing this. In both cases, they were C-suite people, right? So I think it's that's one thing that I've picked up, that it doesn't matter the size of the company. I think it's the kind of training and how you protect your people, right, that are really important. So Patrick, then why don't we move on?
I
Patrick, go
just wanted to open what Amarjit shared, particularly on sexual harassment. I saw one question coming in earlier on whether you're a union member or union leader, and if you escalate this matter and HR is not taking attention to it, supervisor is not taking attention to it, for union members, you can actually come to the labor movement at NTUC or through your unions, and we can file it as a grievance to Ministry of Manpower. If you are victimized or even harassed or face workplace issues. So that's one recourse that we can assist and help you and represent you if you have, particularly in this power struggle, if you are very, very low in the hierarchy and you felt that you may not have the courage to do it, come to us. We can assist and walk that journey with you. So that's one. The other one is, of course, just to add on, I think we have shared earlier the plethora of resources and the go-to and self-help measures which you can take up yourself. I think worst case scenario, I mean, if it's companies not doing anything, supervisors not doing anything, everything is against you. And besides, even I think there was one question, what if the police decide not to even pursue the matter? Yeah, I think there's also civil remedies that you can take personal action against the perpetrator. So do explore the various remedies, including through the POHA as well. So there are we have created all these different platforms, vehicles, and judicial help that you can access in a very economical, effective way. So make full use of that. Like I said, at the end of the day, self-help may be the last resort as well.
Yeah, thank you so much, Patrick, for that. I think, we'll go into a bit more detail in terms of some of the questions. But first, I think I want to do scenario 2, right? Which is this is more for Patrick as well, but yeah, Amarjit, feel free to jump in. So this is what we were talking about, right? The non-traditional, non-office worker kind of work relationship, right? Or work arrangement. So we have in scenario 2, we have a frontline worker who's facing, bullying or harassment at the workplace, right? So I know, for example, in the newspaper articles, we've seen all this security guards, right? Or
right.
even your delivery riders, right? Sometimes, people are frustrated members of the public because you deliver late or whatever it is, right? And then they sometimes get bashed up, right? Physically, basically abused as well, right? So Patrick, in your perspective, and feel free, just like Amarjit, to speak about some of the cases on this, but from your perspective as well, being part of the labor movement, right? What can be done to protect, what can these kind of workers do, and what kind of avenues do they have to get help?
Let me share 3 scenarios. Firstly, a private security guard. Secondly, a healthcare professional, could be a nurse, and as well as some of our private hire as well, taxi drivers. So these are 3 scenarios which are, if you have read the newspapers, it comes up quite frequently, where they are abused either by customers, family members, or even members of public. The very first one, of course, happened not too long ago. You saw this driver in outside Red Swastika School, a private security guard, being nudged with, by a driver in a Bentley vehicle. You can read about it. There were some interesting developments that came after, but essentially these are examples where many of our frontline workers, many of them blue collar as well, face in their workplaces. So in that particular scenario, the private security officer was deployed at a educational institution. And therefore, in that case, he was a union member in one of our unionized companies. We actually provided support. So like I shared earlier, our unions do have support services to help union members who are affected by harassing or even sometimes assault and battery, to assist them in various fronts. Firstly, of course, to file a police report, because I think in some cases it borders into criminal offense as well. And of course, civil action, if they decide to take an action. And of course, more importantly, providing the emotional and other support by visiting them and ensuring the mental health and well-being post the event, because sometimes it may be quite traumatic because of the very, very rapid social media sharing. There is more than just an incident. It stays on. It stays on. So I think the emotional, mental, as well as sometimes even support in terms of helping them access medical help, all these were provided by the union. So that's one example of a situation where if you are frontline of security officer or union member, we can assist you. Same likewise in the healthcare environment. Many of our healthcare professionals are also faced with, particularly in a healthcare institution, most of the time when people go there, they're angry, they're distressed, they're sad, they're happy, and a bit more tensed and a bit more not so even tempered. So I think that's the scenario is okay. Once in a while it becomes a bit of quite hazardous, or put our frontline healthcare professionals in a vulnerable position, because especially when they know their family members are very ill and needing help, and sometimes there's a queue, for example, or sharing a piece of news, or sometimes like what happened in the last 2 years where there are COVID measures and you can't visit your immediate relatives or even very, very close friends, etc. And that's where some of these skirmishes and altercations happen. So that's where the union, as well as and many of the employers, actually have various measures. And if you notice, many of these frontliners do have, particularly in the healthcare environment, have CCTVs, etc., to safeguard the interests and welfare of our frontliners. And the last one I alluded to is taxi drivers, as well as private hire vehicle drivers. And this is a growing group, and they also sometimes face, harassment. Yeah, sometimes they do the night shift. You have people who are, too much of drink, and they come in and besides dirtying the cab or the vehicle, end up hurling abusers and well, in difficult scenarios. Sometimes borders into possible criminal sanctions. Sometimes it may well be they facing needing some reprieve from the taxi hiring companies and companies. So that's where also the union and labor movement does partner some of these aggrieved victims and members in that journey to help to overcome and tell them where to get help, what to do next, and better support them both emotionally and sometimes even financially, and when they need to seek medical attention. So these are examples where we face that. But I'm also glad to share that we have a few iterations of the Prevention from Harassment Act, the POHA. If you look at POHA, if you look closely, in one particular section, if I'm not wrong, in section 6, there's something interesting. We all know that in the penal code, there's a better protection for public servants who are being, there's assault, battery, or even criminal force against public servant. There are additional protection, but the POHA in section 6 actually provides an additional deterrence against harassing behaviors on this term called public service workers. And these public service workers, who are public service workers, there's actually a schedule as part of their whole regulations, and we have updated it. We have lobbied. Yeah, the first iteration came out when the POHA came out, but in the last couple of years, there's a few updates, and I've gotten the team to share. I think we'll post it online. This is the latest one. You can access that piece of document. I think we are posting it by the chat as well. And you can refer to what are the kind of occupations or the areas where these particular occupations and groups of workers are deemed as public service workers, and therefore attract additional protection under the Prevention of Harassment Act, or POHA for short. So if you fall within these categories, mostly covers cleaning, security, public transport, healthcare workers in specific settings. And they have expanded that space also to include, particularly during COVID-19, to those essential workers that have to bet or to work particularly hard in the front line during a COVID-19 pandemic situation. So that's been an update. And that schedule is a floating schedule. Why do I say it's floating? As and when the need arises, the Ministry of Home Affairs, in particular the Minister, can update the schedule and pass new regulations to keep it abreast and relevant to the times. So we are watching this space very closely, and particularly the Labour Woman and myself, and therefore that's why there's a few iterations, and we'll post the latest one up for your reference.
Thank you, Patrick. I think, before we formally go into the Q&A segment, there's one interesting question. You're going through the scenario, Patrick. You're talking about, your gig workers, your delivery drivers, right? Delivery riders and your car drivers, taxi drivers, for example. You mentioned that healthcare workers in the medical setting, usually there are CCTVs, right? But when you're on the go, you're a delivery person or you're basically a Grab driver, right? Taxi driver, for example. You might have outward facing CCTVs, right, for your car crashes, etc. This kind of things. But you don't have inward facing, right? There was a whole discussion, a couple of years back about whether that's allowed or not because of privacy and protection of personal data and things like that. But there is an interesting question here, right, about whether it's legal, right, for this kind of workers basically to wear body cameras, just like how your policeman would wear. Is this something that's allowed under the law? I'm also curious to know.
There's nothing prohibiting that. Of course, you should not be putting your cameras in areas which we are, recording, maybe perhaps a certain, more compromising or more revealing parts or invading the privacy. But essentially to protect yourself, to make sure that you are, if the camera is directed at you protecting yourself, for example, like taxi drivers or Grab riders, where recording conversations. I think this is not new. I think you've seen many parts of the world that introduce this to record all the conversations, so that to look after the interests of both sides. In fact, whether it's the offending party could be the driver himself or the customer, and as long as the cameras are not put in positions which will compromise the safety as well as the privacy of the but essentially to protect yourselves. I mean, if you have a camera facing yourself and someone throws a punch at you, I mean, if it's recorded, I think that's fairly okay. Likewise for Grab riders, I've personally encountered some of them have seen me in some of my Meet the People sessions where they face traffic accidents, for example. So it is helpful. Increasingly, I'm seeing a lot of the delivery champions who are wearing nice cameras on their helmets, on their bikes, just in case, to better protect themselves, in case they are alleged, because you never know. Sometimes, a speeding car next to you may just brush you, and then you get hit off, and then he drives off, and then you don't have anything like our traditional vehicle. So we do recommend and I've started seeing many of our delivery champions, particularly those in the food delivery space, starting to have to install cameras either on their helmets as well as on their mobility devices.
Yeah, so you hear that, folks, straight from Patrick, right? You can use cameras, put them on your, your helmets, your shoulders. Just don't put them on your shoes, right? I think, with all the criminal cases going on for that. So no upskirts and things like that. So, okay, so now let's formally move into the Q&A segment. So just to remind our audience, you can still submit your questions on Pigeonhole, so please do that. Okay, so let me go through some of the questions. Some of the questions that have received quite a few upvotes. So I think the first question is pretty straightforward. The question is, does hurling vulgarities on a regular basis and threatening job security, does that constitute workplace harassment?
Very good question. We're not dispensing legal advice here. It depends on what the vulgarities are. But generally, hurling vulgarities in a workplace is not considered acceptable workplace behavior. It creates a toxic environment. I think there's no question. It threatens the person's psychological safety, particularly if it's coupled with, as you say, threats to their workplace safety and security. I think that creates an environment where they don't feel safe in their jobs, as well as in the physical space with someone who's hurling vulgarities at them. So again, depending on what's being said, how regularly it occurs, etc. It definitely sounds like bullying. Is it actionable? That's a different question. But you're probably not imagining it if this is what you're encountering.
Yeah, I think very important, like what Amarjit shared, the keyword regular and not once off.
Yeah.
Because sometimes it may be at the heat of a moment as an argument and an expletive is being hurled. But if it's constant and regular as what our viewer or audience shared in part of the question, it's very regular and it's like occurring perhaps even on a daily basis, then more than ever it may amount to harassment or workplace bullying.
Yeah, I think that just ties into one of the other questions as well, was about whether if it's a one-off incident, is that considered as workplace harassment? And I think both panelists have just very succinctly kind of summarized that, right? That it's not. It has to be consistent, repeated kind of behavior to constitute that level of harassment, right? Where
Of course, with the caveat, I mean, if it's once-off incident,
That
that
serious
statement is quite
severity.
big. Yeah,
Yes.
I mean, it could be a once-off touch on a certain part of anatomy. That is a no-go.
Yeah.
That may be a criminal offense of outreach of modesty, or even more severe criminal sanctions that can be taken. So it doesn't mean depends on what kind of incident and severity of it.
Correct. I agree with Patrick on this. I think it really is very situational. It depends on exactly what's happening. So bullying generally is a pattern of behavior, right? Harassment can be a one-off. There are cases where harassment, even if it's verbal harassment, a one-off may suffice. Definitely for sexual harassment, a one-off can certainly suffice. So it is very fact specific. But it doesn't mean that you should really keep second guessing yourself and questioning whether you're being bullied or harassed, because if you feel like you are, you probably are.
Yep, thank you both. So let's move on to another question that's got received quite a few upvotes. The question is, what if the management has a culture of brushing off, harassment claims, with comments like, "Oh, too bad you didn't like this particular sexual harassing act," right? And there's no action or very little action that's taken, right? Action that doesn't help the person. Right. It seems like there are a few companies that have this kind of behavior. So, can maybe Amarjit, let's start with you, right? With your experience, you face these kind of issues, right? You just spoken about some of these scenarios, right? So can you just maybe reiterate again for our audience members, like just in brief, what actions can a victim in this case take to protect themselves then? If the company doesn't listen, HR doesn't listen, what can they do?
So I want to go back to something Patrick said earlier, which is companies, employers have a duty to provide a safe working environment. So workplace health and safety is important. They have an obligation to provide it, right? Does it extend only to the physical? No, I think we've received confirmation with the announcement of the latest code for executives and the board of directors that it also extends to mental health, right? So if somebody is being harassed physically, then that's a physical protection of the individual. If it's beyond that, harassment, bullying, there is psychological, verbal, etc., then that goes into the mental health protection as well. So if a company is not responding appropriately to your complaints of harassment, you definitely have other avenues of recourse, right? Which is what we've gone through before. Obviously, the right thing to do is to try and seek help from within the company first, which you appear to have done. And you appear to also have hit a wall insofar as the company responding inappropriately or, saying you didn't like that particular type of sexual harassment, I think is a very offensive response. It's a very inappropriate response to somebody who's complaining about harassment, right? And I think that in and of itself is also something of greater concern. So beyond the perpetrators of harassment, the company's position on this is also wrong. So they should seek recourse based on the various avenues discussed, whether they're unionized or non-unionized. They should explore external avenues of recourse.
Just to add on to what Amarjit shared, I mean, we talked about earlier, both criminal and civil sanctions, or actions can be embarked on depending on how it escalates or blows up and the type of actions the perpetrator does. So, and then you have the POHA court and if some self-help measures as well. At the same time, through the labor movement, through the unions, we can actually take it up as a grievance. If you are in a unionized company, if you're a union member, these are some of the existing measures which you can embark and take.
Yeah, thank you, Thank you, Margit Patrick, for this. So I just want to move on to the flip side then. One of the questions is about the flip side, right? So we're talking about all this, making the claim and how to protect yourself and what you need to do in terms of gathering evidence, getting, your supportive kind of relationships around you. This question is interesting. And it's also got a decent number of upvotes. How do we prevent false claims of harassment in this case, right? What if the supposed victim claims a subordinate harassed them just to ruin the reputation of the alleged offender? Have you dealt with this kind of cases in your in your capacity?
Okay, so this is a very fair question.
Yeah.
It's a question every employer asks themselves, right? Because they also don't have the time or resources
Yeah.
to waste on frivolous claims or false claims, even worse, right? To try and get someone in trouble.
Yeah.
So how do employers protect themselves, right? Because this is less so individuals. Individuals, of course, you want to protect yourselves from false claims, but
Yeah.
how do employers protect themselves? The first thing is have very robust, rigorous policies, right? The GRID policies, grievance investigation, disciplinary. Have all these policies in place. Within these policies include a clause that says, we assume you're making these complaints in good faith. However, if in the course of investigations, it appears that this is a malicious claim designed to ruin someone's reputation or negatively adversely impact their career, then there will be repercussions and disciplinary action taken against the false complainant as well. So it's not just encouraging people to complain for the sake of it, to get others in trouble. Good policies should be balanced, right? So it should state very clearly that if it's a false policy, a false complaint, you can get into trouble yourself. Okay, that's how companies do it. As an individual, how do you protect yourself? Again, if you sense and we have a case where somebody was on the receiving end of a false claim, certain complaints were made, certain allegations were made about inappropriate behavior, and he happened to be taking a video at the time. It just so happened, it was very fortuitous for him because the video showed that he was not doing anything sinister. Where he was, etc. It didn't align with the complaint that was made against him. But he was very lucky because at that point in time, he was collecting evidence without knowing it. He thought it was in an innocent, innocuous situation. It then turned out into, you came to my house and you did this. He's like, no, I was just taking a video of your balcony, and here's the video, right? He got lucky. Not everyone is that lucky. But if you sense that things are going in the wrong way, also start to collect evidence. Because you may end up in a situation where you need to defend yourself or you may need to explain yourself. So it's good to be mindful and to protect yourself proactively to the extent you can, because you don't know what people are going to come up with, but protect yourself. And if you need, tell HR you think things are inappropriate or, things are not going down the right channels, and you may want to have someone sit in on meetings or distance yourself from the individual if you sense it's heading in the wrong way. Yeah.
Like what Amarjit shared earlier, on how victims can take action, whether both in a civil and criminal manner, and the gathering evidence, it works in the converse as well. So likewise for employers, important at the end of the day, shared is the gathering of evidence. I think evidence includes weaknesses, etc. I think it's very, very important. I know some companies in particular, perhaps even frontline or certain parts of the office spaces do have closed circuit televisions, CCTVs. And like I said, I can't mention, or should I say, I can't emphasize more the fact that whether it's in a civil court or in the criminal action, or where before police decides to embark on an investigation, etc., I think evidence is key. Yeah, and of course, if a person does file a false report to the police can also take sanctions against them for filing a false report. So these are the various measures which employers can embark on to safeguard themselves.
Yeah, thanks, Patrick. I feel, personally, I feel like I should walk around with the camera all times, right? Not that I'm being accused of, not that I have actually being accused of this, but I think maybe just in jest, folks. So please don't walk around with cameras
But
on.
I must say these days, I think some of those petty crimes are less prevalent, and because everyone's aware, all of us have very, very high resolution smart devices.
Everyone is a reporter or journalist now, right?
And then we have various police cameras, cam around in key places like lift landings, etc.
Then we have Stomp, right? Vigilante,
yes, of course.
public, right?
Yeah, that's right. And therefore, I think this has helped in a way to ensure we keep the peace and minimize all this. And I'm very sure even if you have seen some of the incidents that happened where there were accusations on harassment hurling abusers, violence, or even outrage or modesty, where actually bystanders were actually filming, and therefore all these are useful pieces of evidence which can help or safeguard both ways.
Yep.
Yeah.
Yeah. Okay, then I think Amarjit, you were speaking about the policies, right? So you need to have good policies in terms of your harassment kind of policies, your investigation policies, grievance handling, disciplinary measures. We have a question here about the investigation bit, right? So what happens if the company director or a senior management personnel, right, is interfering with the investigation by, there's an ongoing harassment complaint that was made, is being investigated right now, but we have someone in senior management, whether the perpetrator or not, right, who's interfering by telling fellow co-workers or other colleagues, right, that, certain perhaps personal views about the victim, right? Like, for example, they cannot be trusted, or, they waste this claim all the time, or, it's just, overreaction or whatever, right? So what can the victim, as well as, I think this is also a question for the company or the HR person, what can they do?
So I think the first thing is that as the company, as the employer, it's critical to set very clear ground rules and parameters when you're running an investigation, right? That involves telling all parties who may either directly or tangentially be involved as witnesses, or whether they're the perpetrator or the victim, that this is confidential. There should be no talk about each other. It's pending investigation. There's no outcome. So there shouldn't be any blaming or shaming, whether in the background or otherwise, and that they shouldn't be talking to colleagues about this, right? Because this is an ongoing investigation. There should be no attempt to color or otherwise influence the outcome, whether it's in the court of, whether it's in the court of public opinion of other colleagues, right? And therefore turning them against the victim perhaps, or whether it's in terms of influencing the people who are running the investigation. So what we often see is that companies get independent investigators to come in who are not part of this, who can lay down the ground rules, even for CEO, and say, look, we've been appointed to look into this to save your company, right? For the purposes of your company, everybody should behave themselves. And we will not tolerate any conduct that looks or feels like retaliation or that is directed at the reputation of anyone who's involved in this process. I think that's critical. As an individual, as the victim, as you say, Sarita, how does the victim stop this? If it has come to the attention of the victim that the senior director is saying certain things, disparaging remarks, potentially defamatory remarks, this should be brought to the attention of the company, particularly the people who are running the investigation, who will then need to inform this director to immediately refrain from such conduct. So they should escalate this because the investigation team may not be aware.
Yeah, thanks, Amarjit, for that. I think it's all these points are very important, right? I think it's both employees as well as employers and the HR and the trained personnel, right, that need to be involved together, right, to investigate this kind of claims and to deal with any kind of interference that happens as well. So we have a couple of questions, actually 2 or 3 questions on TAFEP basically. So I'll just kind of summarize them together and we can deal with them. Maybe Patrick, we'll start with you first.
Sure.
Yeah, so both questions kind of relate to, approaching TAFEP for certain kind of workplace bullying or in one case, sexual harassment as well. And, and TAFEP's kind of response was really lacking, I would say, based on the questions, right? In terms of TAFEP saying that, this is only considered like they can only feed back to the employer, for example, or this is like internal grievance, so you need to handle it internally. What happens in that case, right? What can the affected person go and do, right? Do they, should they be approaching their company again? If they've already approached TAFEP, how does that affect what kind of protections they can get?
Thanks for those questions. I think some of you who may have faced, I assume in these situations when they have approached TAFEP, meaning that they've already tried all recourse internally with the HR supervisors, etc., and it's not being sorted out, you go to TAFEP. TAFEP, in most instances, handles it as a grievance, and therefore will call the employer up. However, as I shared earlier, there are actually other recourses. You have, depending on the kind of harassing act or behavior, whether it's verbal, physical. As shared earlier, you have civil action, which you can embark on. You can take criminal sanctions or by filing a police report if it's an insulting of modesty and where there's outrage of modesty, etc. And beyond the expletives, etc. And there's also the POHA court, which you can embark on if you feel that the action, the follow-up does not suffice. And of course, if you are a union member in a nice environment, go to your union, that we can represent, escalate the matter to Ministry of Manpower and take it as a grievance. So these are the various measures over and above TAFEP. If you feel TAFEP has not been able to address most of your points, I feel you should examine your case. Like I said, incident varies depending on the offending act. You can then decide on what other alternative actions you can take personally.
I also want to jump in there and say
Yeah,
that
of
we've
course.
had experiences with clients who've come to us saying TAFEP had a slightly lackluster response, was not what they were hoping for, and wasn't proactive in resolving their issues. So they ended up in a scenario where the problem remained. There was no solution. So then they actually came to us to seek advice on what form of legal recourse they should be looking at, right? So whether that's commencing civil action, which is very often the last resort, because it's quite extreme, it's expensive, or writing a couple of letters of demand to the company, which usually leads to some sort of negotiated outcome
Yes.
and settlement. But there definitely are avenues, as Patrick said. So don't be disheartened. Continue to explore your options.
Yeah, thanks, Amarjit, for that. Okay, so I think in the interest of time, maybe we'll just take two more questions, but very brief kind of responses. So the first question, Amarjit, this is more for you. I think you spoke about the trend about quiet firing. The question is, what can we do about this, right? Is it the same kind of, I guess from an individual perspective, what can we do, right? And also, I guess, I don't know, not to speak about policy or anything like that, right? But what basically can, HR or employers kind of do to kind of, be trained or combat this kind of scenarios where quiet firing might be happening?
Quiet firing is very insidious. It's usually very hidden. It's not something that's overt.
Yep.
It's just, it's just sending a message to someone that they are not wanted in an organization. So how do you stop it as HR? You train managers that this is not done. We won't tolerate this kind of behavior. If you want to exit someone, there are proper processes to follow those processes, get the approval, and then let them go if it's warranted, right? Quiet firing circumvents all the rules and procedures, which is why it's hard for HR to control. Now, as an individual, what do you do if you feel you're being quietly fired? As mentioned, there is a phenomenon known as constructive dismissal, which is a form of wrongful dismissal. If the quiet firing puts you in a position where you really have no choice, you're compelled to resign because you cannot continue, then that could constitute constructive dismissal. But again, it's a question of severity. It's a question of how bad it is. When does it become legally actionable? That's a very fine question, which you can't answer in the short time Sarita's given me.
Yeah, I think I would like to just ask the audience for a bit more time, right? Because we have a lot of interesting questions coming in, and I want to try to address as many of the questions as we can. So I did promise that we do two questions. That's false. I think we'll do two more questions, right? So so one of the questions really is about we just to be a bit more inclusive, right? For our panel discussion as well. We all know about the repeal of 377A. This question is from a member of that community. So the question is really, what if I'm being sidelined because I decided to come out in my company, right? Whether to your co-workers or not. And then, all this, you were talking about quiet firing, disguised retaliation, whatever, right? So this kind of actions are being taken or behaviors are being done, right? What can they do?
Yeah, maybe I start by before I hand over to Amarjit to give the legal position. But I wanted to start by sharing NTUC, the labor movement's position on this.
Yep.
I think discrimination of all forms, including discriminating against those in this sphere of sexual orientation, is a no-no. Yeah, we want to ensure fairness in the workplace, and discrimination of any kind, whether by age, gender, race, religion, including sexual orientation, will not be tolerated. They should not be discriminated against. And I think that's very, very clear. I mean, whether there's 377A repeal or not, our position has always been very, very clear that no one should be discriminated in the workplace on account of any of these factors.
Yep.
I completely echo that from a workplace perspective as well. I think the repeal of 377A is more symbolic than of practical effect, but it has had a polarizing impact. So we are actually hearing of people who are feeling more pressure after it's been repealed because they have taken a side, right? Or they've expressed a view, or as you say, Sarita, they might even have come up. So that puts them in a sphere where they are opposed to someone else's views because this issue is in the forefront, it's being discussed, right? I'll give an example. Some companies roll out pronoun policies. Now, by rolling that out, are you putting people in a position where they either have to come out or they have to take on an identity they may not relate to, right? And does that lead to discrimination? The answer is probably yes. What do they do about it? I think you need to seek support within the organization that this is happening. I'm not sure how the organization will react because certain organizations are more open to protecting people from the LGBTQ plus space. A lot of them are not yet there. So seeking allyship within the organization is helpful. Seeking support, saying you're being discriminated against. I think it'll be very helpful, Patrick, when we legislate these things, anti-discrimination. I think that will give some teeth to the fact that we do not support discrimination. But as it stands, the penalties, there aren't really penalties, so to speak of. So seek allyship within the company. And if you're really being bullied, then you have all the other recourse that we talked about.
Yeah. Okay. So we'll just take a last question. I'm going to, there's quite a few questions with upvotes, but maybe I'll just lump a couple of the questions together. So these are scenario specific questions, but I'll just give, I'll try to kind of summarize and gel them together. So one of the scenarios, basically it's about, like a harassment behavior, right? So we have in one case, Patrick, you're talking about the public service category, right? Public service. So this is a healthcare worker, works as a clinic assistant. A patient threatened to punch her, or punch them. The police came and only a warning was given. And the employer, basically the doctor perhaps didn't do anything. So that's the first scenario. Second scenario is, one of our audience members was basically, face some sexual harassment behavior quite a few years back, let's just say 10 years ago, right? And I'm also assuming it's in the workplace, but they kept quiet this whole time. And only recently they were dismissed a few months ago, basically. Are they allowed to basically, file a police report? And if the police has, if they don't have like evidence because it happened 10 years back, right? What can they do? Can they still take out a civil claim?
Okay, maybe I'll have a stab at this first. I think there are two questions. Firstly, the clinic assistant. I think very, very important, if you were punched, to have actually gone to get a medical consult to ensure that, if there were any fractures or bruises, right? And you have to do it pretty contemporaneously. So that later on, these are evidence, important medical evidence, so that in case subsequently you may require to take a civil action or even swear a summons in state courts to take an action. Because I suspect, based on the very brief facts, the police may not have investigated because they would have classified this as a voluntary causing hurt situation.
I think it's because it's threatened to punch and not an actual punch.
I see. So even if it's punched, you still need a relevant medical evidence. But if it's threatened, then possibly also verbal threat or some threatening behavior could amount to, perhaps in that case, police didn't escalate to a criminal intimidation situation. But otherwise, all those threat situations will allow you to swear for summons in state courts and therefore take action against the perpetrator. It's so important to get key details, like the particulars of the person, etc., so that you can follow up with those actions and self-help measures. If, of course, in this case, in fact, the employer does nothing. So that's one. The other example on the outreach of modesty, which happened a decade ago. I think these are very brief facts. So I don't exactly know how what's the chain of events that happened and led to her dismissal, whether it's related to that incident or failure to react correctly or behave correctly. But I think in most criminal, in fact, all criminal cases, if it has really happened, there's no time bar for him or her to take an action. However, this is 10 years ago. My only biggest concern or worry for this audience who have filed this question is, do you have the evidence that it was committed? Were there witnesses? And were witnesses able to come up to testify? Because whether it's in a court of law or in any other kind of investigations, unfortunately, you still need the requisite evidence. And the contemporaneous reporting does make or break sometimes some of these cases where it's your word against mine.
I totally agree with what Patrick has said. In the interest of brevity, I'll only say in the first scenario could also be a POHA offense. because it's a threat, would have caused harassment, alarm, distress. And it's also a threat in and of itself. So yeah, apart from that, nothing really to add. I do like Patrick's point on if you've been hit, go and get medical evidence. Same with a rape kit. If you think there's been rape or any sort of you have injuries, go and seek medical or professional opinion, because that actually is evidence. And you should do it as soon as possible so as to preserve the evidence.
Yeah, thanks. Yeah, unfortunately, I mean, as much as I would love to take a few more questions, I think we're out of time. So before we end, Patrick, Amarjit, I want both of you to just give me just 30 seconds, right, for each, just one key takeaway that you want our audience members to take from this conversation that we've had this evening.
Yeah, maybe I'll kick off and say, that we have surfaced through this evening sessions some of the key resources or go-to guides that you can access in a very easy way, in a very easy to read and accessible way, and therefore make full use of those and to find out what your rights, your responsibilities, especially some of you who are employers, and of course where to go to. Whether you're a worker, whether you're a gig worker, whether you're a part-time worker, whether you're a traineeship, whether you're on an apprenticeship, all these resources will address those burning questions that you may have. So don't lose heart. I think there are various self-help measures beyond what is existingly available in your companies as well.
Thanks, Patrick. A bit longer than 30 seconds, but I think we're good. So Amarjit, for you, what's your one key takeaway that you want our audience to go away with?
Okay, my parting message is that I hope victims of bullying and harassment at the workplace have realized through the course of this session that you are not alone. The question was, the title is there recourse? The answer is yes. I hope we've shed some light on what you can do to help yourselves. Employers, the way you set out your policies, etc., the way you look after your employees, I think that's critical. I hope that we've shared why it's important. So please do better. Thanks.
Thank you both so much. I think it's great, and I think the only regret I have is that we've only had 90 minutes, right? Slightly over 90 minutes for this. I wish maybe the next session that we do together, we can do it 2 hours long, right? Yeah. So folks, we've come to the end of our webinar. At the end of the webinar, before you exit, there will be a survey form that will pop up on your screen. For your completion. We would greatly appreciate your comments so that we can improve our future webinars. I also want to just give a shout out to Law Awareness Week. So we have a lot more webinars going on for Law Awareness Weeks at CDC 2022. Please scan the QR code on your screen, or visit the website also on your screen, so that you can register for our other webinars that are going on. And remember, if you're facing workplace safety or workplace harassment issues, and if you are an NTUC member, you can always register for a legal clinic session at NTUC. You can write to, I think the email address is on the screen. I see it right now. lawworks@ntuc.org.sg. That's for if you're a union member. And then, of course, you can always just generally write to the Law Society Pro Bono Services. So the email address is enquiry@lawsocprobono.org. With that, finally, I just want to say thank you so much to both Patrick and Amarjit. It's been great. Thank you so much for sharing, your examples, your case studies, your knowledge, your experiences with us. I'm sure our audience members are giving you probably, a lot of standing ovations, a round of applause. And, I would love to just give you final, I don't know if I can say thank you enough, right? Thank you so much for joining us today. Thank you so much for sharing your knowledge. And to everyone, have a good week ahead. Thank you so much.
Thanks.
Thanks.